October 25, 2018, the Malaysian government published a Federal Government Gazette on the declaration of alteration of port limits for Johor Bahru Port. Singapore, in response to that, lodges a strong protest with the Malaysian government, urging that Malaysia refrain from taking any further actions and unilaterally to amend the Gazette notification. Malaysia Transport Minister Anthony Locke finds that Singapore's claim is inaccurate and the altered port limits were within the Johor Bahru port's limits and also within the Malaysian territorial waters. Malaysia Prime Minister Dr. Mahathir Mohamad says that the government is prepared to conduct a survey on the maritime border of Malaysia and Singapore to see if it is true that Malaysian ships are truly intruding into the Republic waters. In response to that, Singapore ministers also claimed that Malaysian government vessels have repeatedly intruding into the territorial waters of Tuas with 14 intrusions so far. In Minister of Transport Khaw Boon Wan says that out of the blue, Malaysia is claiming these territorial waters that belong to Singapore without any prior consultations. Malaysia is seeking to alter unilaterally the long-standing status quo in the area. This is a blatant provocation and a serious violation of our sovereignty and international law. So Malaysia proposes to Singapore for both countries to cease and desist from sending assets into the disputed area. Prime Minister Dr. Mahathir Mohamad says that Malaysian vessels will stay put in the disputed waters until the dispute is completed and settled. So, in response to that, Singapore has strongly urged Malaysia to withdraw completely its vessels from the disputed waters, which is claimed to be its territorial waters, and then file a declaration with the under the clause to ensure that Malaysia does not unilaterally commence third-party arbitration without the consent from Singapore on their ongoing maritime boundary disputes. We can see that this is not the first time that Malaysia and Singapore on dispute on the issue of the maritime boundary disputes. There is also other disputes that happened before this, which we can claim as which we can refer as well. Yet in 2002, there's also another dispute concerning land reclamation works between Malaysia and Singapore. On January 2002, Malaysia sent protest note to Singapore stating that the reclamation work in the area between Malaysia and Singapore has encroached into the Malaysian territorial waters. On March 17, 2002, the Johor Port Authority also confirms that Singapore's reclamation works are affecting the Johor ports of Pasir Gudang and Tanjung Pelepas. On March 17, 2002, Singapore says it will continue to carry out land reclamation despite complaints from Malaysians that such work disrupts shippings and access to the environment. On July 4, 2003, Malaysia referred this issue to the International Tribunal for the Law of the Sea to request for provisional measures pending the setting up of the arbitral tribunals. On both of these issues, let's see what the experts is going to comment on these disputes by both the countries.
Actually, starting in 1960, Singapore has reclaimed land for industrial, housing and infrastructure purpose. One of the most well-known projects is Changi Airport, which located at the eastern part of the mainland Singapore. While the issue in 2002 was concerned about massive land reclamation project in Tuas and in Pulau Tekong, which located at the southwestern tip of the mainland Singapore and in a separate non-eastern island respectively. And in January 2002, by the time the Singapore land reclamation project in Tuas had progressed for more than 1.5 years, then Malaysia started protesting the project by complaining the land encroachment into her territorial waters, and another subsequent protest was made in April 2002 for the issue of various impacts arising from the project. In a nutshell, Malaysia accused Singapore of reclaiming land in a way that trespassed on her territory, narrowed and constrained the navigation in the Strait of Johor, and caused various damages to its marine environment, including the reduced catch of the Malaysian fishermen. So, in July 2003, Malaysia invoked Article 286 of UNCLOS and initiated an arbitration. However, the arbitration efforts afterward had not produced any fundamental changes for the dispute, and in September 2003, Malaysia had applied to UNCLOS for provisional measures pending the arbitration outcome. For the judgment by the ITLOS, the arbitral tribunal delivered a unanimous judgment prescribing a set of provisional measures with regard to the establishment of a group of experts on assessing any adverse effects or risks of Singapore works. A very important point to note is that as the court considered neither Malaysian claim to an area of territorial sea nor a situation of urgency, a sufficient basis for the prescription of provisional measures with respect to the reclamation in the sector of Tuas. And finally, in 2005, Malaysia and Singapore had agreed to sign a settlement agreement to bring an end to the dispute over the Republic's land reclamation in the Straits of Johor.
Would be that Malaysia have extended the Johor Bahru port. So in this dispute, Singapore have claimed that the extension that was made had encroached into the Singaporean territorial waters of Tuas. However, Malaysia said that the claim was inaccurate, pointing out that the new port limits were in the territorial sea. Our Transport Minister pointed out that Singapore's extensive land reclamation in the area in question did not extend the state's base point or its baselines. So now we'll go into the issues, prospects and challenges of this current issue. The first would be the extensive reclamation works carried out in the area which resulted in Singapore's coastline have been altered significantly. This does not give Singapore the right to claim a new baseline from which their maritime boundaries are to be measured. Land reclamation does not extend the state's territorial waters. It is imperative for Singapore to identify its original baseline and limit its reclamation works within what is allowed under the provisions of UNCLOS with regards to rights of state within their territorial waters. Secondly, our Prime Minister Tun Dr. Mahathir, while having responded diplomatically, have indicated that there is a need to settle the current dispute between the two states based on legal rights and provisions. This shows that Malaysia is rather keen to pursue an adjudicative method instead of a consensual or voluntary process of dispute settlement. Diplomatic methods in solving disputes between the two states had proven how Malaysia had been shortchanged time and time again, and understandably, our Prime Minister sees the need to change this. However, this is not applicable as Singapore had submitted its declaration under Article 298 of UNCLOS in not accepting any of the procedures provided for in Section 2 of Part 15 regarding the compulsory procedures entailing binding decisions. This means that the adjudicative tribunal is now out of consideration. The only method to pursue now would be via consensual or diplomatic channel. It is important to note that Singapore have previously opened to submit the previous disputes to adjudicative tribunals, including the Pedra Branca case that was submitted to the ICJ under the provisions of UNCLOS. A consensual or a diplomatic approach here is definitely not the way to go, as Singapore was the party who has made strong claims that Malaysia's act is blatant provocation and a serious violation of Singapore's sovereignty and international law. This shows that there are more reasons for Singapore to opt for adjudicative tribunal to deliberate and make definitive decisions on the maritime boundaries based on international law and principles, rather than depending on diplomatic measures to provide an effective legislative outcome.
So what is the major impact then of this maritime boundary dispute towards our beloved homeland Malaysia? Since Singapore has blocked the adjudication resort, leaving consensual or diplomatic channels as the sole way out, let us deliberate on the available measures. The measures would be those provided under Section 1 of Part 15 of UNCLOS, which are essentially methods provided by Article 33 of the UN Charter on Pacific Settlement of Disputes, which are seeking solution through negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. Of course, subjecting the dispute to judicial settlement are out of the question at this point. But which of the remaining peaceful dispute settlement methods would be mutually agreeable to both the states then? And more importantly, which of the methods would be the most effective and successful in settling this dispute given the fact that the exactly same methods have been applied and adopted by the parties for years in almost all of their disputes without any significant or positive outcome. So, having said that, even if the parties decide to resort to adjudicative method, it may not necessarily have led to a full-fledged, final, and all-encompassing judgment either. This was quite evident in both the land reclamation and suffrage case. Let us go back to peaceful dispute settlement method. The disputing parties could consider to recourse to the regional dispute settlement procedures and mechanisms under ASEAN umbrella. Chapter 9 of the ASEAN Charter provides that disputes not relating to the interpretation and application of any ASEAN instrument are to be resolved in accordance with the 1976 Treaty of Amity and Cooperation in Southeast Asia. In short, TSC. The ASEAN Charter resonates the TSC in that it provides for the first line in settling disputes to be in the form of dialogues, consultation, and negotiation. The mechanism under TSC consists of the High Council, comprising of one representative at ministerial level from each ASEAN member states together with representatives of non-ASEAN members which are directly involved in the dispute, whereby in the eventualities of unsuccessful negotiation, the High Council is to recommend appropriate means of settlement such as the use of good offices, inquiry, conciliation, or mediation, which is in engaging a third party in different capacities to assist in settling the dispute. Malaysia and Singapore may request the chairman or the secretary general of the ASEAN to provide his good office or to take the role of a conciliator or a mediator. However, both Malaysia and Singapore must agree for TSC mechanism to be applicable at the first place.
So firstly, Singapore initially drew its territorial sea delimitation depending on its reclaimed land being the starting point and baseline for the calculation of the territorial sea. However, Singapore was actually wrong in doing so because by using its reclaimed land to determine the baseline, it is not in accordance to the UNCLOS. If we refer to Article 11 of the UNCLOS, only the outermost permanent harbour works which may form an integral part of the harbour system are regarded as forming part of the coast, which in this case, the reclaimed land is not the permanent harbour works. So second, on 7th of December, Malaysia proposed to Singapore that both countries should actually cease and desist from sending assets into what they call as a disputed area. However, Singapore rejects that proposal and reiterates that Malaysian government vessels should leave its waters, which it was pointing to the disputed area. So from here we can see that Singapore has actually acted in a way which might have caused an escalation in the tension between the two states. Whereas on the other hand, Malaysia's proposal was actually a very good way to relieve the tension at hand and may prevent further tension between the states which might arise from the disputed area. So Singapore should have actually borne in mind that in settling the dispute, both the countries should actually make it a peaceful way and by peaceful means. So to sum up the dispute, the latest maritime boundary dispute between Malaysia and Singapore has its roots from the issues which has been boiling for years. Bilateral methods has proven to only provide temporary resolution before new related disputes will have inflamed again. So most cases have seen Malaysia being rather shortchanged through bilateral dispute resolution means, and Singapore does not seem to be open to revisit and renegotiate those resolution in light of new development and circumstances. The nature of a negotiation is that there must be some give and takes. As long as one party only takes, negotiations are doomed for failure. Maritime boundaries are matters pertinent to states' territorial sovereignty and should be resolved by adjudicative tribunals. Even so, there are stalemate situations such as this. As long as Singapore is adverse to submitting this dispute to compulsory procedures, which promise a final and binding decisions, there seems to be no light at the end of the tunnel.